Let's start the second part of our interview with Professor Cedric Reinhardt. Today, we will discover the notion and the phenomenon of extraterritorial state jurisdiction and maybe other type of jurisdictions. Professor, while the general principle in international law is that a state's jurisdiction is limited to its own territory, that's the territorial concept of jurisdiction, the extraterritorial jurisdictions allows states to extend their legal reach in certain circumstances. My question is this one. What are the general rules on extraterritorial state jurisdiction? And a little bit of legal history. What is the importance of the decision of the Permanent Court of International Justice in the Lotus Case, judged in 1927? We can wonder if this decision is still accurate today.
Yeah, thank you. This is a very important judgment indeed. So let me start with that judgment. The famous Lotus judgment. This is so far the only judgment of the World Court dealing with the fundamentals of the law jurisdiction in the history of the World Court spanning more than a century. And that Lotus decision has been characterized as a high watermark of jurisdictional laissez-faire liberalism, in as much as the court stated somewhere, and I'm paraphrasing the dictum of the court, that states can do as they please, jurisdictionally speaking, as long as there is no prohibitive rule to the contrary. It's something that I already touched upon earlier. But on closer inspection, if you read Lotus carefully, the Lotus judgment may in fact have been based on the territoriality principle after all. Now, remember that this Lotus case for the listeners, it concerned a collision of two ships on the high sea, so you could say outside the territorial jurisdiction of any state, involving a French vessel and a Turkish vessel. The Turkish vessel sank, and Turkey then claimed jurisdiction over the officer of the watch of the French ship, the Lotus, causing the incident. But at the time, in the 1920s, ships were in fact considered as pieces of floating territory. So the judgment was arguably based on territoriality, because there was a problem with a territorial, you could say, entity, a territorial object. Still, so regardless of the specificities of this case, this is an important case also in the law of the sea, but if you look at it more from an abstract perspective, you still have that general dictum of the court on this liberalism. You can do whatever you want. And occasionally states or authors continue to invoke that fundamental principle to justify novel jurisdictional assertions that are not like widely accepted just yet. And they would say, well, basically states can do what they want, and if you don't like it, you have to prove the existence of a prohibitive rule to the contrary. So you could say that the burden of proof then shifts to the state protesting the exercise of jurisdiction. So we've seen, for instance, that Lotus has been relied upon to justify the exercise of universal jurisdiction in the absence of the perpetrator, which is really quite controversial in the law of jurisdiction. But if you espouse a liberal approach, that could be justified. Now, a couple of years after Lotus, in what I consider to be a reaction to the Lotus principle, scholars at Harvard University embarked on an important project, which has unfortunately not materialized yet, aimed at codifying the rules of criminal jurisdiction across the board, including extraterritorial jurisdiction. And they came up with a draft convention. It never made it into an actual convention, but still there is an important draft on jurisdiction with respect to crime, produced in 1935, 90 years ago. And there, the authors essentially disavowed the liberal Lotus principle, and instead they espoused a much more restrictive approach, by virtue of which states can only exercise jurisdiction if based on a permissive principle of jurisdiction. And this approach is, of course, quite different. In principle, you cannot exercise extraterritorial jurisdiction unless you can rely on the nationality principle, the protective principle, or the universality principle. But these are basically the only principles. So there's a limited category of principles of extraterritorial jurisdiction that are convincing in international law.
Thank you, Professor. In this interview, we realized that the legal power of the state is very diversified, and that this complex power of the state allows it to ensure control over various matters that cross national borders. And you spoke a little bit about the differences between territorial jurisdiction, personal jurisdiction, universal jurisdiction. And my next question is about that. Could you share with us the different types of international jurisdiction of the states?
Well, I would say for pedagogical purposes, a distinction is traditionally made between three main types of jurisdiction. So this is used in the literature. Courts or states do not always refer to these types, but one distinguishes between prescriptive jurisdiction, enforcement jurisdiction, and adjudicatory jurisdiction. And this distinction harks back to earlier restatements of U.S. foreign relations law. Let's start with prescriptive jurisdiction or legislative jurisdiction. This denotes the power, the authority of a state to lay down laws, to prescribe laws, to legislate, basically, to adopt legislation. So that sounds a bit abstract, but think, for instance, of a state amending its criminal code and giving its prosecutors and courts universal jurisdiction, so without any connection with the state, over acts of corruption. Now, as to prescriptive jurisdiction, extraterritoriality is certainly possible, at least in the criminal law, as I said, based on nationality protection and universality. The second type of jurisdiction is enforcement jurisdiction. It denotes, again, power and authority of the state, but here to enforce its laws. And this type of jurisdiction is decidedly territorial. So in principle, there are no exceptions for extraterritorial enforcement jurisdiction. You cannot send your police forces abroad. You cannot just conduct inspections on someone else's territory unless, as I said earlier, you have the consent of that territorial state. If you don't have the consent, in principle, it is an internationally wrongful act. Now, in the digital sphere, the territoriality of enforcement jurisdiction is currently under pressure. As we've discussed earlier, in relation to loss of knowledge of location regarding data. So some states have started to retrieve data that is likely held abroad. Often they don't know. It's about cloud services. You don't know where the server is, possibly, or you access computer systems that may well be based abroad, but again, you're not entirely sure, without obtaining the consent of the territorial state, simply because you can't identify the territorial state. So you have a clear problem there. Sometimes states have relied on internet service providers like intermediaries to produce such data as well. Now, it's not fully clear whether this burgeoning practice is in keeping with international law. So this is really shifting, and I've published on that recently as well, that in Western countries, this is really shifting, but in non-Western countries, they might have a very different view, which is more based on strict territoriality than we have in a couple of more open economies, also more digitalized economies. Adjudicatory jurisdiction, and finally, yes, that's the third type that I would like to mention here. That refers to the powers of the courts and the judiciary to settle disputes with a transnational dimension. Now, I'm not entirely convinced whether we actually need a separate category of adjudicatory jurisdiction. If you talk about public law, criminal law, taxation law, for instance, courts will normally just apply the law. The judge is la bouche de la loi, as they say in French. So it's just a modality of prescriptive jurisdiction, you could say. Yeah? They're just there to apply the law as it has been adopted by the legislator. But At the same time, we've also seen that some domestic courts are willing to review a national public authority's jurisdictional assertions in light of the higher international law of jurisdiction. So perhaps there is indeed a separate role to play for adjudicatory jurisdiction to review domestic law in light of higher international law. Just to give you one example, perhaps from the field of extraterritorial taxation, something that I've looked into recently. There's an interesting case from 2012 before the Supreme Court of India. So these evolutions are not just happening in the US or in Europe, but also in India. The court ruled that a particular jurisdictional assertion by the Indian Tax Authority, that's a public agency, violated public international law as it created tax liability in India in relation to a purely offshore extraterritorial transaction between two foreign companies. One of those companies held a stake in an Indian company, but that was only an indirect link to India. And the court said, well, there was no genuine connection with India because the nexus was too indirect and the tax was therefore internationally unlawful. So you could say that's a form of adjudicatory jurisdiction, but also linked with questions of prescriptive jurisdiction. And prescriptive jurisdiction, as I said earlier, is fundamentally based on the principle of genuine connection.
Thank you, Professor, for this explanation about the distinction between these three types of international and national jurisdiction. With the complexity of social, commercial, and political relations in the world today, it happens that jurisdictions overlap and enter into competition or even conflict over the same event or the same person, even if this question may involve activities which take place beyond their borders. So what happens when two states are concurrently competent for this event or this person or this activity? And what can be the reaction of a state to the extraterritorial normative action of another state?
Well, indeed, concurrent competence, concurrent overlapping jurisdiction is a distinct possibility indeed in the world that we live in today. I've pointed out that there are multiple principles of jurisdiction which multiple states could apply to the same situation or the same person even. And states could even apply the same principle of jurisdiction, in particular territoriality, in case a situation has territorial links with more than one state. So multiple states all invoke the principle of territoriality because they say, well, one of the elements of a state of affairs has a link with my state, and the other state, well, the other element has a link with my state. So you can imagine the problem here. And as we discussed before, in light of globalization, digitalization, and the attendant relativity of borders, a multi-jurisdictional or a multi-territorial situation is not unlikely. Think of, for instance, an anti-Semitic statement on the internet. Any states where this statement could be read by a user of the internet could, in principle, claim jurisdiction. And the question arises how to handle these conflicts of jurisdiction. Now, the starting point in traditional jurisdictional theory is that there is no hierarchy between jurisdictional principles. They are all equally valid as a matter of international law. This is why we have seen a quest for second-order jurisdictional principles, genuine connection, comity, and reasonableness, which I have already mentioned. And the idea is then that states only exercise their jurisdiction if they have a strong enough connection or interest. And the idea is that they defer to other states, which can make a stronger jurisdictional case. Now, in the end, the way forward would be to have consultations between states on the exercise of jurisdiction, who has first right of way. This is really necessary. In some conventions, especially in the criminal law, for instance, conventions on corruption, they already provide for a duty to enter into consultations in scenarios of overlapping jurisdiction when you have like an international corrupt scheme. There are also bilateral agreements, for instance, between the United States and the European Union on international antitrust enforcement since the 1990s. And I think we need more of these. But at the end of the day, such arrangements are not the silver bullet. Consultations will only work if there is a willingness to talk and a basic degree of trust in each other. And consultations do not guarantee a particular outcome, of course, especially when the stakes are high. States may be unwilling to give up their jurisdictional claims, and this may lead to conflict. For instance, I'm a bit concerned over a looming jurisdictional conflict between the US and other countries under the incoming Trump administration in relation to extraterritorial sanctions. Remember that in his first administration, President Trump turned out to be a particular fan of using economic sanctions to put pressure on other states to change their ways. In 2018, for instance, he reimposed extraterritorial sanctions on foreign persons, including EU operators, dealing with Iran. Jurisdictionally speaking, the US claim was based on national security and territoriality, but of course, other countries would argue that the US claim is, for all intents and purposes, extraterritorial in nature and impinges on the territorial jurisdiction of other states. They would claim we have jurisdiction. These are our operators. We claim first right of way based on the territoriality principle. So you have a clash between different principles or applications of different principles. And you can imagine that European states, but also any other state might say, well, this kind of secondary or extraterritorial sanctions, they interfere in our free sovereign choices to conduct economic relations with states such as Iran or with any other state, Russia, China, even North Korea. So let's hope we can still talk to the Trump administration moving forward on tariffs or regarding extensive jurisdictional claims.
Thank you, Professor. Let's speak now about the EU, European Union, and a little bit more about the US. The European Union has significant extraterritorial normative regulatory power, meaning the EU can influence and regulate conduct outside its borders through its laws and policies. What are the forms of this EU's extraterritorial normative power, Professor?
Thanks for that question. Indeed, so we have a tendency to talk a lot about US extraterritoriality. And the US is the country that has most conspicuously projected its power in an extraterritorial fashion. Antitrust law, criminal law, sanctions regulations, as I already mentioned. But indeed, the US is not the only entity using extraterritoriality. We have the EU as well, and in fact, all powerful entities, political, economic states, regional organizations may be interested in doing extraterritoriality based on the capacities which they have. Let's turn to the EU indeed for a moment. I think the difference with the United States and perhaps also with other powers is that on paper, at least, the EU will only project power abroad to advance shared norms and values. This is this whole idea of normative power Europe. So then we talk about human rights, we talk about sustainability, the environment, or international law more generally. And this is in keeping with the constitutional mandate of the European Union under the Treaty of the EU. Article 3 refers to this duty to respect shared norms and values. For that matter, the EU doesn't actually say that it exercises extraterritorial jurisdiction. And this is for strategic reasons. As in the past, the EU has criticized the United States for exercising arguably unlawful extraterritorial jurisdiction. So in the literature on EU extraterritoriality, typically another term is used, territorial extension. I think Professor Joanne Scott came up with that term in a 2014 article. And the idea here is that the EU relies on the uncontested, non-controversial principle of territoriality, and on that basis extends its power abroad. So let me give you an example of how this works in practice, because this might sound very abstract. Under multiple recent EU regulations, you can only import certain goods into the EU, put them on the EU market, if the foreign production process, so leading to the production of that good in another country, complies with EU standards that are, according to the EU, in line, and obviously with international standards. That remains to be seen, obviously, but still. Think of the new EU deforestation regulation. There's a lot to do about that regulation these days. It will apply in the EU from the 30th of December 2024 onwards. And under that regulation, operators, business persons basically, can only place on the EU market products that are deforestation free. So meaning that the production of these products, think about wood, for instance, or rubber, or even coffee, does not contribute to deforestation in the country of origin. So think of countries in Africa and Asia and Latin America. So clearly there is an extraterritorial impact that the EU wants to make the world a better place, you can say, wants to protect forests and the environment. So there's an extraterritorial intention, but using the principle of territoriality. The goods cross the borders, of course, at one point they're imported into the European Union. And just one other example, briefly, just early November 2024, the Council of the European Union adopted a new regulation that bans the importation of products made with forced labor. And arguably, this will make it more difficult to import products from, for instance, Xinjiang in China, or Turkmenistan, North Korea. It has been alleged that forced labor is used there. So again, what is happening here is that the EU uses a territorial hook, the placing of a product on the EU market, to influence production processes abroad. You could say, well, this is not really an exercise of extraterritorial jurisdiction, because no extraterritorial obligation is actually imposed on a foreign operator. And indeed, that's true in a way. Foreign operators, they can continue to produce their goods as they please, but the only consequence will be you cannot not sell your goods on EU markets. Now, such territorial extension, for that matter, can also work through export regulations, and the US has done that for a long time. And it seems that the EU is now also copying from the US playbook in that respect. Under the EU sanctions regime against Russia, for instance, it's really interesting. Sanctions can be imposed on foreign operators. Let's say you're a foreign operator in Armenia or in Kazakhstan, and you purchase goods from the EU, but you re-export those goods, EU origin goods, to Russia, but they're banned goods, actually. Yeah? So if an EU operator would immediately export them to Russia, that would not be possible. So also these indirect imports, these re-exports, re-exportations are really problematic, and the EU has prohibited this and can impose sanctions on foreign operators. Again, you could say, this is what the Commission would then say, well, there is a territorial link. The goods originally came from the EU as original territoriality, but this link is then used to influence transactions and processes outside the territory of the EU. So as I said, there is an intention to change extraterritorial practices. So in terms of effects, it's really extraterritorial.
About the USA, the United States is a prominent actor when it comes to extraterritorial jurisdiction, as you said. US laws often apply beyond its borders, and you gave us some example in the first part of this podcast. especially in the fields of trade, finance, sanctions, and foreign policy. What is the practice of the United States in terms of extraterritoriality? What is the theory of undesirable effects?
Yes, I already referred a lot to US practice, so I'm not going to repeat everything I said, but what I want to emphasize is that the US is still the most powerful country in the world as we speak. So it's not a surprise that it is the country that most often resorts to extraterritoriality, and I would say as an alternative to war, for that matter. And the US can do so because it controls the choke points of global economic governance, especially in the financial system, something that you already mentioned, and also in political science. Henry Farrell, Abram Newman have pointed that out in their writings. And the US, as a major power, can also engage in extraterritoriality because it doesn't have to fear retaliation as much as smaller countries do. Yeah? And this practice didn't start in the 18th century, of course, when the US became independent from Britain, but it started only in 1945, I would say. And it's right before, not after, but before the end of the Second World War, when the U.S. Court of Appeals for the Second Circuit, one of the more important court of appeals in the U.S., upheld the effects doctrine. So that was one of your questions as well. And what about the theory of undesirable effects? So that's the effects doctrine in the field of antitrust law. So ever since 1945, the US could claim jurisdiction over foreign antitrust conspiracies, which cause adverse effects in the United States. For instance, you have a conspiracy hatched somewhere else, which artificially inflates prices for products sold in the United States. At the time, this led to a lot of conflicts with other countries which did not have very strong antitrust laws at the time. Now, it's interesting that later, late 20th century, early 21st century, many countries started to copy the US approach, and they also started to rely on the effects doctrine when enforcing their own competition laws. And the Court of Justice of the European Union has just recently confirmed the validity of applying the effects doctrine as a matter of both international and European law. Now, it would back to the US for a moment. It would lead me too far to explain all the different instantiations of extraterritoriality in the United States. But as you said, indeed, it's really focused on a couple of fields: sanctions, anti-corruption, but also drug trafficking, for instance, terrorism, often national security related, digital enforcement as well. But at the same time, and I would really like to emphasize this, and it's not well known perhaps outside legal circles, there is a strong push in the United States against extraterritoriality. So a push in the United States itself, not coming from outside the United States. And most notably, the US Supreme Court, relying on a canon of statutory construction called the presumption against extraterritoriality, which applies to all statutes of the United States, in principle federal statutes, I'm talking here, this court has severely curtailed the extraterritorial application of, for instance, the Alien Tort Statute, which is a statute about extraterritorial claims by victims of human rights violations, has curtailed the extraterritorial application of U.S. capital markets regulations, for instance. It's also striking to me that, unlike in other countries, like countries in Europe, for instance, that the United States has hardly ever exercised extraterritorial jurisdiction over core international crimes like war crimes, crimes against humanity. There are no traces of universal jurisdiction in the United States. So the US is not all about extraterritorial jurisdiction. It's really focused on particular fields of the law, economic law, national security law.
Thank you, Professor, for this presentation of the EU's and the US extraterritoriality powers. We are coming to the end of our interview, and I have three little more questions for you. An author wrote a book on digital empires, empires that want to impose their power in the global digital order. This author, Anu Bradford, distinguished three competing regulatory approaches. the American market-oriented model, the Chinese state-oriented model, and the European rights-oriented regulatory model. I wonder, what do you think about this presentation, about this analysis? And could the global private companies be interpreted as a functional legal power outside any territories?
I think this is a very important question also going forward. So let me say two things here. First, and this is something that we already see today, private companies are sometimes enlisted by the state as what I would call jurisdictional subcontractors to do the work for the state. And second, and I think that's a more fundamental shift, something that you referred to in your question, private companies may start exercising jurisdiction, authority, in their own right, without state interference at all. So let me unpack this for a moment. First, these private companies doing the work for the state. Now, private companies these days may be more powerful sometimes than states, or at least have a better informational position than states. They have more information. They hold more data than states. So we've seen that states increasingly rely on companies, use them as gatekeepers for the enforcement of the law. Not all companies, typically technology companies and financial institutions, sitting on troves of data, tech giants, obviously, sitting on troves of digital data. And law enforcement may, of course, be quite interested in accessing these data. So we've seen that law enforcement agencies in the Western countries have directed orders to tech companies, but also outside the West, lately forcing them to produce relevant data which they control. Also in the field of sanctions, for that matter, we've seen that governmental authorities rely very much on the private financial sector to monitor compliance with also extraterritorial sanctions regulations. So the point here is this is about delegating law enforcement to the private sector. Second, we've also seen that owing to deregulation, private companies start to float free from government regulation. They start to float free from state jurisdiction. And I think this process is only going to expand, especially in the United States under the new Trump administration, which has promised to further deregulate the tech sector, including cryptocurrency markets, for instance. So the end result may be that tech companies start exercising their own jurisdiction. So as a user, you may be subject to the company's policies, to the company's jurisdiction, rather than to the jurisdiction of any given state. So it becomes deterritorialized, you can say. So when you have a problem with the company, or the company has a problem with you, the company may propose non-state-based binding arbitration based on company rules, so regardless of any applicable state territorial rules. So we may be on the cusp of a fundamental shift from public territorial jurisdiction to private non-territorial jurisdiction. And there is a key normative question here, of course: is this shift desirable? Can we trust companies to defend public values? Can we trust companies to protect weaker parties? But perhaps that is a subject for another podcast.
Thank you, Professor. I have a question about indigenous people jurisdiction, because we spoke about state, we spoke about alliances between merchants, we spoke about global private powers, we spoke about the EUs, but a lot of indigenous people nations exist today. And I'm speaking from the traditional territory of the Lekwungen peoples in the Salish Sea region in Canada, in the province of British Columbia. What do you think about this notion of jurisdiction for the indigenous people? What legal considerations arise in this context?
Oh, in all honesty, I have not, I don't have very deep thoughts about this. What I'm thinking of now is jurisdictional pluralism, so that indigenous peoples may possibly live under their own laws, based on a constitution. You're probably also referring to Canada, for instance, but also many Latin American countries where a certain sovereignty, you could even say, or indigenous sovereignty is recognized in relation to natural resources, but also in relation to culture, spiritual sovereignty in a way. And some of these communities also have their own tribunals, for instance, or their own dispute resolution mechanisms, which exists alongside state mechanisms. But I believe it's important that they are recognized by state law, that you have a state act recognizing these pluralist institutions. But I think this is important in terms of recognizing the diversity of jurisdictional approaches, which might be quite different. I mean, an indigenous or a tribal approach might be very different from the mainstream approach in particular states. So, yeah, very interesting question, but it's not something that I have dealt with in my own research so far.
Thank you, Professor. My final concluding questions makes the final links between the notion of jurisdiction and the academic field of border studies. Finally, Professor, what are the contributions of the notion of jurisdiction to the border studies? And could we say that borders have completely vanished, or could we say that we have understood borders wrongly?
Well, yeah, I think in a traditional view, as I said, borders are seen as absolute limits to jurisdiction. So the state has exclusive jurisdiction over acts within the borders, and the state has no truck with what happens outside the borders. But as said, borders are not absolute, right? Maybe they have never been as absolute as it is claimed. And these days, there is international migration, international trade in goods and services, global communication, international financial transactions. So this means that sets of facts often have a transnational dimension, also in the digital sphere. For instance, evidence for use in criminal proceedings might be on a server abroad. You may not even know. So there is transnationalism without you realizing it. So multiple states may have a jurisdictional interest in regulating. And we've seen that especially powerful states with an open economy like the US, the European Union, they have engaged in various forms of extraterritoriality simply because they have the capacity to project their power. They're countries of immigration. They boast trade and financial hubs, and foreign countries, operators, individuals are partly dependent on those other countries. And this gives then the EU, the US, the chance to govern globally, to extend their borders, I would say, not so much geographically, but extending the borders more in a functional sense, right? So the US may then become a global regulator, mostly for sanctions and corruption, whereas the EU may be a global regulator for data protection and perhaps the environment. But this is only for the time being. The relative power of the West is declining. So it is expected that other countries like China or India might increasingly assert their own extraterritorial jurisdiction, something they have not done before. Actually, they have invaded against the West's extraterritorial jurisdiction, but as they become more powerful, quite probably they will use that tool of statecraft as well. So my estimation is, my prediction is that more jurisdictional conflicts may actually loom on the horizon.
Thank you, Professor. And if we think a little bit more about the transformation of borders and the transformation of the thinking of borders, maybe we could think about borders as strategical porous institutions by nature, not only used as a tool or as a jurisdiction tool at the territorial level to protect the enforcement jurisdiction, and at the functional level to let the normative power goes beyond the territorial borders, but we could imagine the concept of borders as a porous object inside the concept itself. I don't know what are your thoughts
Sure, yeah,
about that.
right. Yeah. And extraterritoriality could then also be used as a tool for accountability in relation to human rights violations, environmental law violations in other countries. So there is also what I would call really good extraterritoriality, and I'm glad then that the borders can be porous, the territorial borders can be porous. Of course, territoriality remains with us. Think about immigration control, for instance. There you clearly see that there may be a hard border, but apart from that, international crimes accountability, environmental accountability, you really see borders becoming increasingly porous, and something that is to be applauded in the absence of an international regulator. So that's a problem here that we face, that states go it alone. They act unilaterally. They make borders increasingly porous because there is no international supervisory body. The UN is notoriously weak. Also, the World Trade Organization has become notoriously weak. So you see states going it alone and extending their borders. This is the concept of territorial extension that I used um, for certain functions of the state, not for everything, obviously. The US is a global hegemon, but does not control the entire world. Obviously, there is still a concept, and that's where I started, a concept of state sovereignty, of territorial state sovereignty. There are 194 states still which have their own territory, and they can still claim jurisdiction over their territory. Yeah? But territoriality has become more relative over the years. Territory has become more porous. Indeed, as you said, borders have become more porous.
Thank you, Professor. And last thing about the Schengen Agreement, Professor, we have some example of shared enforcement jurisdiction between different binational team with so a team with national agents from two countries who could operate in both territories in the borderland, you know. So even though the enforcement jurisdiction is very protected, we could see also some adaptation in this field with this example of binational police or custom team which can operate both sides of the borders. But the exception is, of course, if it's a Belgian agent who is operating in France, he could follow the criminals, but he can arrest it, but he can't bring him back to its own territory. You know, so even though the enforcement jurisdiction concept has also some kind of adjustments, you know.
Absolutely, but that's all consent based here, so that's based on prior agreements. So these states do so on the basis of an agreement they have, and this is all steered by the European Union. Of course, there's more mutual trust within the European Union, so you can imagine that this materializes in the EU rather than elsewhere. But it's a good model, indeed, perhaps to export to other countries with a high level of mutual trust, that you trust each other's law enforcement agencies operating on your borders. But unfortunately, in the current state of affairs of the world, there is a lack of trust. I'm not quite sure whether it can be replicated elsewhere as we speak.
Thank you very much, Professor Cedric Reingart, for this conversation about the complex legal notion of jurisdiction and the different types of jurisdictions. It was a very dense and very informative discussion, and we can hope to have opened an innovative field of research in border studies. Thank you very much, Professor.
It was my pleasure. Thank you for having me.
This was the Borders in Globalization podcast. Thank you for your attention and see you soon for the next issue. Bye bye.